Imagine signing a lease for your dream home, a spacious 3-bedroom house where you and your fiancé are planning to build your future together. The landlord shakes your hand, looks you in the eye, and assures you that the attached apartment will stay empty. You believe him, you move in, you settle in, and then slowly you start to notice things. A car in the driveway that wasn't there before, lights on in the apartment late at night, the sound of footsteps, voices, and then one day it hits you. Your landlord hasn't just been visiting, he's moved in, permanently, right next door to you, without your consent. This is the situation one Texas tenant found themselves in, and what they discovered about their legal rights might just change the way you think about your lease forever. So let's set the scene here, because the details of this story really matter. We're talking about a single-family home in Texas, a 3-bedroom property that was listed and advertised as exactly that, a single-family home, not a duplex, not a multi-unit property, a single-family home. The couple who rented it were excited. They were engaged, planning a future, and this house felt like the right place to start that chapter. The rent was agreed upon, the paperwork was drawn up, and they were ready to move in. Now, there was one thing the landlord mentioned during the signing process. Attached to the main house, and this is important, there was a small apartment. The landlord explained that it had been built for an elderly family member at some point in the past and that it was no longer in use. He said it would remain empty. He verbally assured them of this, and to be fair to him, he did include a clause in the lease. But here's where things get interesting, and honestly, a little suspicious. The clause didn't say the apartment would remain empty. It said the landlord could access that apartment at any time. At the time, the tenants probably didn't think too much about it. Maybe they figured it was a standard clause. Maybe they thought it just meant he'd come by occasionally to check on the space. Whatever they assumed, they signed the lease and moved in. And for a while, things seemed fine. But then, things started to change. The landlord didn't just come by occasionally. He didn't pop in to check on the apartment every few weeks. He moved in, him and his wife, together, making the attached apartment their full-time permanent residence. And when the tenants really started looking into the situation, the details only made things more complicated. There were no separate utility meters for the apartment. The electricity, the water, the gas, all of it ran together. There was no separate mailing address either. In the eyes of many legal and practical definitions, this wasn't truly a separate unit at all. It was, for all intents and purposes, part of the same home that the tenants had rented and believed they had exclusive use of. Think about what that actually means in day-to-day life. You wake up in the morning and your landlord is right there. You have an argument with your fiancé. Your landlord is right there. You have friends over on a Friday night. Your landlord is right there. You want privacy in your own home, the home you are paying for. Your landlord is right there. It's not just an inconvenience. For many people, it would feel like a violation. And legally speaking, the tenants began to wonder, is it? They turned to the internet for help, and the legal community had a lot to say. Let's break down exactly what their situation looked like from a legal standpoint, because there are actually several different angles here, and each one is important. The first issue is the lease itself. The landlord included a clause giving him access to the attached apartment at any time. But there is a significant legal difference between access rights and the right to take up permanent residence. Access clauses in leases typically refer to the landlord's right to enter for inspections, repairs, or maintenance. They do not typically grant the landlord the right to move in and live in the property. Courts have consistently interpreted these kinds of clauses narrowly, meaning in favor of the tenant. If that clause said access only, it almost certainly did not give the landlord the right to establish a full-time home there. The second issue is the advertising. The property was listed as a single-family home. That's not just a marketing term. It can have real legal weight. When you advertise a property as a single-family home and someone rents it based on that description, there's an implied representation that you are renting the entire property for your exclusive use as a household. Having the landlord actively living in an attached unit fundamentally conflicts with that representation. This could form the basis of a misrepresentation or fraudulent inducement claim, meaning the tenants may have been tricked into signing a lease under false pretenses. The third issue is one of the most powerful tenant protections in landlord-tenant law, the covenant of quiet enjoyment. Almost every residential lease in the United States, including in Texas, contains either an explicit or implied covenant of quiet enjoyment. What this means, in plain language, is that the tenant has the right to live in their rented home without interference or harassment from the landlord. Having the landlord physically living next door, sharing utilities, with no real separation, that is a textbook argument for a breach of the covenant of quiet enjoyment. The tenant's ability to live peacefully in their home has been materially compromised. The fourth issue is the shared utilities situation. With no separate meters, the tenants may be subsidizing the landlord's utility usage, or at minimum, there's a shared arrangement that was never properly disclosed or agreed to. This could be relevant to both a breach of contract claim and potentially a deceptive trade practices complaint under Texas law. So what can the tenants actually do? They ask specifically about a cease and desist letter and a potential lawsuit, and the answer is yes, they likely have strong grounds for both. A cease and desist letter is a reasonable first step. It formally puts the landlord on notice that his current living arrangement is considered a breach of the lease agreement, creates a paper trail, and gives the landlord a chance to remedy the situation before things escalate. In Texas, written notice matters enormously in landlord-tenant disputes, so having that documentation is crucial. If the landlord ignores the letter or refuses to vacate the apartment, the tenants would likely have grounds to sue for breach of contract. They could potentially pursue remedies that include the right to terminate the lease without penalty, meaning they could move out and not owe the landlord anything more. And they might also be entitled to damages, which could include compensation for the period they have been living under these conditions. There's also the possibility of filing a complaint with local housing authorities or the Texas State Attorney General's office under the Texas Deceptive Trade Practices Act, particularly given that the property was advertised as something it arguably wasn't. Now here's what every renter watching this needs to take away from this story. First, read every single word of your lease before you sign it. The landlord in this story included an access clause that the tenants may not have fully understood at the time. That clause became the legal fig leaf he tried to hide behind. If you see any clause that seems unusual or vague, ask about it, push back on it, and if needed, consult a lawyer before you sign. Second, document everything. From the very beginning of a tenancy, keep records. Save your listing advertisements. Save your email correspondence. Write down conversations that happen in person and send a follow-up email summarizing what was discussed so there's a written record. If something goes wrong later, documentation is your most powerful weapon. Third, know your rights around quiet enjoyment. Most tenants have never heard of this legal concept, but it protects you from exactly this kind of situation. If your landlord is making your home life miserable through interference, harassment, or intrusion, whether that's moving in next door or something else entirely, that covenant may be your strongest legal argument. Fourth, in Texas specifically, the landlord-tenant laws do provide meaningful protections for renters. Don't assume that because a landlord is bigger, wealthier, or more experienced than you, that they automatically win. Tenants have rights, and courts do enforce them. And finally, if you're ever unsure, consult a tenants' rights attorney. Many offer free consultations, and organizations like Texas Rio Grande Legal Aid provide free legal help to qualifying individuals. You don't have to navigate these situations alone. If something like this has happened to you, if a landlord has violated your lease, moved in without your consent, or made your home feel like anything but a safe and private space, know that you have options. The law is often more on your side than you might think. If you found this video helpful, please give it a like and subscribe to this channel. We cover real legal situations that real people face every day, breaking down what the law actually says in plain, straightforward language. Hit the notification bell so you never miss a new video, because knowing your rights might be the most important thing you ever do.